I want to bring in Philip Dubé. He's kind of been on this journey with me through these motions to suppress since the very beginning, and he's been right on all of these issues. He's court-appointed counsel. He is based in Los Angeles. So, Philip, with the investigative genetic genealogy motion to suppress, I mean, all of these motions to suppress were denied, but you believed that this would be denied because you didn't believe that Bryan Kohberger had a privacy right to other people's DNA uploaded to a public database. And the judge found there was no Fourth Amendment violation here.
That's correct. He had no standing, as we call it in the law. And the U.S. Supreme Court revolutionized the standing rule back in the 60s in a case called Katz, K-A-T-Z versus United States. And what a defendant has to show just preliminarily to suppress a search warrant or a search is that he or she has a subjective expectation of privacy, and objectively, it has to be the type of interest in privacy that society is willing to embrace. The court found no, he had neither. He didn't have a subjective or objective expectation of privacy. Instead, everybody else maybe who was in the database that uploaded their DNA did. And the right to suppress evidence is not only personal to a defendant, but the item that you're seeking to suppress has to be personal to that defendant as well. So, for example, had the family of Bryan Kohberger been charged, that might be a different conversation because his heir's DNA was uploaded into these private data banks, and they have their own privacy and contractual interests in the specimens that were uploaded. But as to Bryan, the judge got it right.